In Weyerhaeuser Company versus United States Fish and Wildlife Service, we'll see whether an agency's decision to protect an endangered frog's habitat was subject to judicial review. Historically, the dusky gopher frog lived throughout Alabama, Louisiana, and Mississippi. Over time, 98% of the frog's habitat was lost to agriculture and development. By 2001, there were only 100 dusky gopher frogs left in the wild, so the Fish and Wildlife Service listed the frog as an endangered species on behalf of the Secretary of the Interior. When the Secretary lists a species as endangered, the Secretary must also designate the critical habitat of the endangered species. Under the Endangered Species Act, the Secretary must consider the economic impact and other relevant impacts of designating critical habitat. The Secretary may exclude areas from the critical habitat designation if the Secretary determines that the benefit of excluding land outweighs the benefit of designating the habitat. In 2010, the Fish and Wildlife Service proposed the critical habitat designation for the dusky gopher frog, which included a 1,500-acre site in St. Tammany Parish, Louisiana, referred to as Unit 1. Dusky gopher frogs hadn't been seen on the site since 1965, and in its current state, Unit 1 didn't meet the frog's specific habitat requirements. Weyerhaeuser, a timber company, owned part of Unit 1 and leased the remaining land in Unit 1 to a group of landowners. Once land is designated as critical habitat, the Fish and Wildlife Service would have to be consulted before development permits could be issued, and the service could potentially bar any future development on the land. Weyerhaeuser and the landowners, referred to collectively as Weyerhaeuser, filed a lawsuit to vacate the service's decision to designate Unit 1 as critical habitat. The district court upheld the service's designation. Weyerhaeuser appealed, but the Court of Appeals affirmed the district court's holding. The Court of Appeals held that the service's decision to designate Unit 1 as critical habitat was a matter committed to agency discretion. Therefore, the service's decision was unreviewable. Weyerhaeuser appealed again. The United States Supreme Court granted cert.